is the day after the Court of Appeal gave the IEBC a go-ahead to print the presidential ballot papers with the Dubai-based printer Al Ghurair. This and other political campaigns and the events informing our dawn debate this morning. In studio, I'm now joined by lawyers Joy Brenda Mudivo, Paul Aol, and Harrison Kinyanjui. Welcome, ladies and gentlemen. Thank you for joining us this morning. And of course, this ruling given by the appeals court yesterday, well, some have said it's a win for IEBC. Others have said it's a win for Kenya. Let me start with you, Harrison. Your thoughts?
It was a long time coming.
It's a win.
Coming? It was a long time coming. I mean, this was something that we should never even have gone to court about. Why I say that is because it made no sense to me. It still doesn't make sense to me why, if you're given a slice of chapati out of, if you're given a whole chapati, it's sliced into 6 slices, you eat 5. And then when you come to the 6th one, you say, oh, you know, this chapati was badly cooked. Take it back. You've eaten 5. It doesn't make sense to me at all. So you have a group of people who are comfortable, perfectly happy, and have absolutely no qualms accepting 5 election ballot papers being printed by this company, whose printing was through direct procuring. But when it came to the presidential election, they had a problem. So you can see immediately at once, on the face of it, there is a problem with that logic, that reasoning, because if you allege that there is something discrepant in the presidential ballot printing by this company, there ought to be, by the same logic and argument, something discrepant about the other 5 other election ballots. But it was not so. So that's why I'm saying it's a win for the Kenyan electorate. When you want to elect your leaders, you want to elect the whole gamut of them. You don't go and elect only 5 of them. There was a legitimate expectation on the part of voters who stood outside. And curiously, NASA did not want the public participation of these voters in the case because they never in the first place enjoined them. That legitimate expectation was that they would go on 8th of August for the election, for the entire gamut of election, the 6 of them, but not 5 of them. But so there was a planned short-circuiting of that entire exercise being conducted and concluded in respect of the 6 elections. So the Court of Appeals verdict and resounding reminder that the elections are on 8th of August is welcome.
All right, Joy, did you expect the same?
I did, actually. The problem with what we had in this scenario is that we allowed partisan political interests to interfere with technical work that the IEBC was given to do. The act of procurement is an administrative duty. It is not legislative, it is not policy. So public participation, for example, would be as far as open tendering goes, or as far as advertising for the same. That would be construed, in my opinion, would be sufficient for public procurement. Why am I talking like that? It's because we don't just procure ballot papers. Government officials and government agencies procure many things. And the tendering process, by and large, is supposed to be open and transparent. But the decision finally rests with the person who is left to carry out the work. Now, if you remember, this process started way back in 2016, when the first open tender was done. It was challenged. Then they went for another process, said, okay, what the former IEBC started with, the Chebukati team has to start afresh. By that time, they're already feeling the crunch of time. So they decided, okay, fine, to do restrictive tendering. So it was kind of open, but not quite open. They ended up still with Al Ghurair. Then after that, after the court decision, they said, you know what, now we're just going for direct tendering. Why? This is a company that they already had a relationship with. They knew their capability, they knew what they were going to bring on the table. So when we finally went to court and the decision comes out and all the prayers fail save for public participation, I was a bit gobsmacked, to be honest. And then when the courts went on to fall short to define how that public participation should look like, with such little time, you know what would have expected was, we expected public participation to look like 1, 2, 3, 4. And Judge Odunga, for example, had defined himself, actually had another matter before where he actually set out step by step what he expected public participation. But in this particular matter, they decided, okay, we don't know what it looks like, but you go ahead and decide what it looks like. with 25 days to go. I found it, so when the judges came back yesterday with that decision, I found it a win for Kenyans. Because for us lawyers, we can pontificate, and when you look at the letter of the law, yes, you can see where the judges were coming from. But if you are a normal Kenyan waiting for an election on the 8th, your basic question was, do we have an election or not? And that's why I was glad the judges decided to restate that, yes, we do have an election on the 8th. And by having the presidential ballots printed together with the others, also takes away the others who, let's say you may go for the gubernatorial and you're unsuccessful. And the first point of call when you're filing your election petition is, by the way, this tendering process. Because there's already precedent. So it actually takes away that particular aspect for all the other election petitions that we're expecting to come after the election. So I'm quite happy with the decision of the court, and I'm hoping after the elections, we will take time to unpack this Elections Act properly and to set proper procedures so that moving forward, we don't have this avalanche of last-minute challenges to everything, because that was our problem. The laws were changed too quickly, too soon to the elections, too drastically.
Is it possible that the last-minute avalanche is maybe on purpose? There's somebody who says that, so many politicians thrive in chaos.
That's what Jubilee has been alleging. Jubilee's argument has been, this is specifically designed to short-circuit the 8th of August so that we can go into a caretaker government. That's why they're talking about Lusumkate. Because if we don't have an election on the 8th, you're going to a caretaker government. And now, when you get to that point, they seemed to have a legitimate argument. I cannot speak for NASA. I don't know whether that was really their strategy. But it is hard-pressed to see how it's not a strategy when you have filed 19 matters against the IEBC.
Okay. Let me hear from you.
Basically, I don't know why we as Kenyans have decided to look at it from the point of who won and who lost. Because actually, if you look at some of the issues that were being determined at the Court of Appeal, one of them was even the issue of bias, the issue of special relationship, the issue of procurement. And actually, if you look at what was actually determined, I'm wondering why people are celebrating. It got to the point of, was the High Court right to exercise its discretion given the timelines that this election had to be done? They were very clear, and actually when they came to the issue of public participation, whether it's restricted tendering or direct tendering, what is the process and what was supposed to happen. Actually, this Court of Appeal decision came to the issue of discretion. Was the High Court right to exercise its discretion without considering the timelines? Because I think the Court of Appeal's opinion was that after we've considered all these things, the legitimate expectation of Kenyans is we must have elections on 8th. So I don't really know why people are actually celebrating on who won, who lost, because you look at the legal issues that were actually determined. I can tell you it's a very good judgment, because actually right now, like for example, it defines what is special relationship. Like, was there any special relationship between Al Ghurair and the president of Kenya? Because this judgment even defined and said election is not really an event. It's a process. And what needs to be considered before that 8th. And actually, if you read it's 104 page, the judgment, you realize that maybe because we are politicians, some people want to be politicians. They want to limit this thing into Jubilee and NASA, who won and who lost.
And I was going to say, I'm not sure it's so much a celebration, but the fact that Kenyans, like Joy says, want to know, are we going to have the elections or not? So this gives us a green light to go for the elections. But let me come back to you, Joy. And the question now being, now that the Court of Appeal has ruled that way, is that likely to cast aspersions to now how fair the elections are going to be? Because NASA could come out and say, look, we told you guys that this was not right. Now this has, can it muddy the water, as it were?
No, to their credit, actually, the NASA advocates came out and were very categorical that they were not going to the Supreme Court, that now they would concentrate on trying to finish the other matters that they have pending. Because I think there's a decision we're expecting today, and there's still one more matter that is pending. So their in-tray is still full at this point. So I think they've chosen this particular fight, let's end it here. But one of the things that also we must also laud this entire process is that it has actually put to test the veracity of our laws. one of the criticisms I've had with this constitution is that it tried to be the Grundnorm and the statute rolled into one. So when you have that, there's several prescriptive descriptions in the constitution, then you go ahead and have statute, then you go ahead and have subsidiary legislation. As advocates, I think we need to come to a place where we audit the document and say, look, let's just leave this one here, and the rest of it, let it be prescribed by Act of Parliament, because the Parliament will be alive to the prevailing circumstances, and we should be able to trust them. Secondly, I think some of these acts, we should have a prescriptive time buffer and say we cannot amend certain acts within, for example, the Election Act, let's not amend it within a year once the IEBC timelines start running, let's not.
Sorry, I'll have to cut you short. I understand there's a problem with the mic. Let's try and fix that. But let me hear from you, Harrison, in regards to the way forward. Now, and I mean, we cannot go back on the judgment. That's already been done. Basically, Al Ghurair continue with the printing of the ballot papers. Hopefully that sets us up and it gives IEBC now time to concentrate purely on ensuring that they deliver a credible election. Hoping that nothing else comes up.
Hoping. But you never know what they might spring up. It's NASA Brigade. They always have something up their sleeve. Now, before I come to that, let me clarify something. This case was filed by NASA. They enjoined Jubilee. So it was more of the political contestants themselves going into the ring. And so my client came into the case as a voter. The 19.6 or so million voters had no voice in that case until we came on board and said, wait a minute, there is something beyond that voting exercise that you want on your side, because Article 38 has a flip side. The voter has a right to cast a vote and to elect the person of their choice. And so the issue of public interest is what then we table before the court and say that, look, public interest overrides the allegations of public participation that they allege was not executed or undertaken. And then we question, how is it that you would like public participation in direct procurement? And I'm happy what Joy has said, that this decision has enabled the filtering and the sieving out of some issues that needed clarification, and the Court of Appeal has clarified. Again, I would agree with her. The Kriegler report had said that 6 months to the elections, you should not do anything to interfere with the IEBC. Again, to ensure that the timelines that are set in the Constitution, in order to deliver a credible, a transparent election, those are not interfered with in the slightest. But we have 2 weeks, barely about 10 or so days to the election. Still, they want the BVR kids, I don't know, they were not given a chance to participate in their testing. They would like the register to be removed, you know.